Good afternoon, everyone. This is Steve Wilkes. Welcome on behalf of the Wagner Law Group. I'm speaking to you from our San Francisco office. I'm joined today by my colleague, David Gabor, in our Boston office, the partner in charge of our employment law and litigation practice. Hi, David.
Hi. Good day, everybody.
And we appreciate very much your joining us. Let me set forth the agenda here on slide number 4 and tell you what we're going to cover. We'll put a little perspective and try to frame the issue, if you will, on the problems that arise around the classification of employees and independent contractors, or the misclassification, some of the business issues and legal issues that come up, the definitions for each of these employment categories and the risks, the upsides and downsides, some of the problems we see in the I'll talk a little more about some of the issues that come up in the tax and employee benefit world and some things that can be done with the IRS. David will lead our discussion on issues that arise under the employment laws, for example, wage and hours and employment law statutes. And we'll try to give you some best practices and next steps for what you can do to mitigate these issues or resolve these issues in your corporation. Slide 5. So to put a little scope and a little frame on this at the moment, it's a pretty big issue. There are a lot of independent contractors in the workforce, and many of them, we know as a result from various audits that have been undertaken, are misclassified. Tremendous amount of work has been done here. There have been studies going back on behalf of the federal government, which estimate, revenue just on employment taxes, lost wages of $3.3 billion back in 1998. 2000 study commissioned by the Department of Labor that found between 10 and 30% of audited employers were misclassifying their workers. Government Accountability Office, staggering numbers, billions of dollars in revenues lost. Congressional Research Service has done a lot of work in this area. So there's a lot of data out there that we have on this. And the states have also had some task force and studies on it as well. And the impact on this can really be catastrophic, both to the business and to the employee if a worker is misclassified. And it goes a little bit, we think beyond the dollar issues of including or excluding someone from a benefit plan or failure to collect revenues for the states or municipalities or the federal government. There's some cultural issues too as to how you just work and lead your workforce and the management issues that go along with that. So our goal today is to try to talk about what is the legal issue, how do you define these categories, what are some of the issues that come up you should be looking for in terms of consequences, and what can you do to maybe make it a little better and avoid these problems going forward. Slide 6. Now there's a lot of people have a standing in this. We often hear about it, when you're talking on the street and you talk about the employee independent contractor issue. It usually comes up. People are talking about the IRS and employment taxes, but as you can see here, there are many stakeholders. The Department of Labor looks at it in terms of wages and overtime. Immigration is a big issue in terms of the record keeping that would be demanded of an employee versus an independent contractor. The DOL and IRS, Pension Benefit Guarantee Corporation, with all the pension and health schemes in terms of reporting and disclosure. The IRS, similarly on employment taxes. HHS on Medicare benefit payments. Social Security Administration, National Labor Relations Board, the right to organize. Employment discrimination, and the state and local agencies all have parallel interests as well. And David will talk about some of these on the employment side, and I will follow through on the tax issues. But you can see there are a lot of stakeholders. It's a pretty big issue. So again, slide 7, just in terms of what's the tension here? What's really happening? Well, for one thing, we know that workers really fall into 2 basic categories. You're either an employee or an independent contractor, and we know that telling the difference is very fundamental and important to the implementation of these various laws. We also know it's very complicated. I know there's a Supreme Court case that we'd like to quote as lawyers every now and then that was decided a number of years ago, and they said that few problems in the law have given greater variety of application and conflict in the results than the cases arising in the arising in the borderland, that's the Supreme Court's word, the borderland between what is clearly an employer-employee relationship and what is an independent contractor. So it's a pretty tough issue. Obviously, from the employer's perspective, oftentimes it's financially advantageous to push people out or to maintain people at arm's length as an independent contractor. It's not just the dollars. You know, you're avoiding potential tort liability. Maybe you're allowing for some work schedule flexibility. Sometimes it makes sense. You want people as employees. Obviously, governmental agencies want them for revenue collection. An employer might want to classify one as an employee rather than an independent contractor. It gives you a chance to protect and own the intellectual property that is developed. And we see that a lot. I'm here in California. We see that a lot, of course, in with our Silicon Valley clients. Slide 8. So there's a lot of activity, tremendous amount of activity going on here. The IRS has the Employment Tax National Research Project. The IRS and various states have multiple agreements in place, memorandums of understanding and task force where they're agreeing to pledge dollars to audit and enforce on this issue, to investigate this issue. They've targeted certain industries, construction, hotel, janitorial, sometimes where lower paid wage workers aren't as savvy or sophisticated about protecting their rights. High tech is targeted because there's such a large number of independent contractor computer consultants and software developers. They love to come in and do their own thing and just have a independent contractor arrangement with the company, part of that culture, if you will. We also see a lot of this with our financial service clients, with our broker-dealer clients, where there's a tension between the registered rep, the financial advisor in the field. Is that individual an independent contractor or an employee? And there's lots of implications there. Legislation, constant legislation because of the revenue-raising potential in this area that we see proposed. President Obama has had something in his budget for the last couple of years about increased enforcement and potential statutory changes in this area. So it's a hot topic, and it's getting a lot of attention. And as I said before, one of the hardest parts about it is to really understand the technical or legal definitions of an employer versus an employee versus independent contractor. And with that, I will ask David to take over here on slide 9.
Thank you, Steve. One of the biggest challenges we have in this area is to understand actually what is an employee and what is an independent contractor. And for a long time, the IRS had a 20-factor test that it used to define the independent contractor. And people from the IRS, the Department of Labor, different state agencies, judges in a variety of different courts, and practitioners all scratched their head and couldn't quite understand really what the definition was. And if all these people can't do it, it's really hard for employers to do it. So the IRS recently simplified its 20-factor test and created an 11-factor test that's broken down into 3 basic groups. There's the behavioral control function, financial control, and types of relationships between the employer and the worker. Slide 10. So let's first take a look at the behavioral controls. And the first one is the instructions given to the worker by the business. And I'm using the word worker to define the individual who ultimately may be an independent contractor or an employee, but for purposes of the webinar, we're calling the person a worker. And basically, what the instructions relate to is the employee, whether the employee is generally subjected to the business's instructions about when, where, and how to work. And I'll give some examples of types of instructions about how to do work. When and where do you do the work? What tools or equipment are being used? What workers what workers to hire or to assist with the work. So for example, if you're working for X Corp and you're bringing people to help you with a project, are you picking the people or is X Corp picking the people? Where to purchase your supplies, the services that you provide, what work must be performed by a specified individual, and what order or sequence to follow. And there is a correlation between the amount of instruction and whether or not the person is an independent contractor or an employee. The greater the instruction, the more likely the person is an employee. The less the instruction, the less likely the person is an employee. But keep in mind, as Steve pointed out before, the government has a very strong incentive to call people employees, so any one factor will not be dispositive on whether the person is an independent contractor, because the government is still going to try to push to find ways to make the person an employee. So even if no instruction is given to the individual, the worker, it's still possible to find that the individual is an employee and not an independent contractor. And then the other factor under behavioral control is whether or not the employer is training the worker. You know, are they training the person on how to do the job, or is the person learning the skill from an outside source? Let's look at slide 11. Now we're going to talk about financial control. And factors that are considered are whether the individual has unreimbursed expenses. Because traditionally an employee advances some expense for the work, the employee gets paid back. An independent contractor would not be paid back. So that's one factor that will be considered. A second is going to be the extent of the worker's investment. The more that a person has an investment in this work, the more the person is an independent contractor and less likely an employee. Because employees usually have no investment in the work other than their time. At the same time, an independent contractor often has significant investment in the facilities he or she uses in performing services for someone else. But as it's a common theme, because of the government's desire to call people employees, a significant investment is not necessarily dispositive on the issue. The extent to which the worker makes services available to the market, and this one's important. If an individual provides services to X Corp and to 2 or 3 or 4 other companies, more likely than not, the court would consider them to be an independent contractor. And that actually would be a very important factor. How the business pays the worker. On this one, we're looking at whether a person is paid every 2 weeks, twice a month, once a month, a flat fee for services. You know, and then they look at how the company pays its other employees. You know, are they paying employees biweekly, semi-monthly? You know, and they look to the pattern and the way these people are being paid. Finally, does the person experience profit or loss? Employees don't experience profit or loss. They have a paycheck. They may get a bonus periodically, but they don't experience profit or loss. Independent contractors might. So let's look at slide 12 and the type of relationship. The first factor is whether or not there's a contract between the the worker and the employer. Now, this is the one that the IRS says is the least important criteria because of the fact that an employer can create a contract, but the mere fact they have the contract doesn't mean the person's an employee or an independent contractor. It just means the employer is calling the person an independent contractor. And that's the Microsoft case that came down a few years back, which was, you know, the Supreme Court was square on that particular issue. Next is whether the worker receives traditional employee-type benefits. And this is also not as important. And this goes into, by the way, the risk associated with misclassification. If the person is receiving health insurance, any other kinds of benefits, sick pay, vacation pay, holiday pay, they're more likely an employee, but the fact that they're not receiving those may become a potential liability for the company down the road. The longer the relationship lasts, the more likely that the DOL, the IRS, another agency or court will consider the person to be an employee and not an independent contractor. And finally, the extent to which services performed by the worker are a key aspect of the regular business of the company. The more that the services relate to what this company does, the more likely it is that the Department of Labor or IRS would consider them to be employees and not independent contractors. Slide 13. just to make it even more frustrating for companies, a lot of states have their own laws on the independent contractor versus employee relationship. Many times, these laws are actually more favorable to the employee-employer relationship. A big reason for that is because of the huge costs that the states and the federal government experience when people are being misclassified as an independent contractor. One number, for example, if 1% of companies misclassify employees, it costs $198 million a year for unemployment insurance alone. And that's just an example of the financial impact. Also, please keep in mind that you can be a company that's located in California and you have a person who's performing services for you in Oregon that you believe to be an independent contractor. Oregon law may apply as well as California law in deciding whether or not this person is an employee or an independent contractor. So it's important to be mindful of the law where the person is working, not just the law where the company is located. Slide 14. And Steve, can you talk a bit about some of the risks for misclassification, please?
Yeah, thanks, David. So let's assume that an employer has made an error and the classification, is inappropriate. How can that impact in a real sense? Where do the consequences lie? Well, one of the big issues, of course, is the retirement plans. David before talked about Microsoft, where independent contractors who were found to really be, quote, employees were eligible for the retirement plan. And to go back a number of years and include, they've been improperly excluded. So you had to go back a number of years and include them and make up catch-up contributions and interest on that and so on and so forth. And by the way, in the Microsoft case, which is kind of like the iconic name brand court case in that era, there was also a huge gap on the equity compensation. The way a lot of the stock option plans were defined, it was for employees. So they had to go back and recalculate stock options, and it had a major impact on the statement, on the financial statements and the equity section in terms of the number of shares issued, outstanding, under option, what have you. It was pretty significant. Same thing on health plans. The medical and health and other welfare plans, if tax issues, really employment tax issues that need to be considered if they're not properly withheld. You have some states that have gone beyond merely collecting money or reclassifying. They've become very aggressive. For example, California, a year or so ago, added a statute which makes it a crime for what they call the willful misclassification of employees. And we're still, we'll wait and see how the courts, define, willful in this case, but it's pretty onerous. And, wage and hour issues in terms of calculating minimum wage, and your rights to make claims, or how the relationship with people versus discrimination laws and claims under workers' compensation. So it's pretty big. So specifically, just to give you a quick laundry list here on slide 15 on the federal tax issues. What are the potential issues there? Well, you have on the employer contribution side, you have FICA, Social Security tax, which goes up to, I think it's about $114,000 this year for for each misclassified worker. That's the cap at the salary level. You have Medicare. You have unemployment tax, the FUTA tax, and then you have under the Affordable Care Act, otherwise known as Obamacare, you have the shared responsibility payment. The IRS has the responsibility to enforce and collect these payments for, employers with full-time, with 50 full-time employees that are, perhaps improperly not extending health coverage to the right people. So that could be pretty onerous. And on the employee side, of course, there's an employee portion for FICA and Social Security and Medicare as well. And in terms of, the penalties are legion. You have there's a negligence or substantial understatement penalty, there's a fraud penalty, there's a fine involved per employee for not providing the correct Form W-2, there's a penalty for failing to file employment tax returns, there's a penalty for not timely filing your employment tax deposits. So it can get to be pretty rigorous. The same thing, parallel, I can use California as an example, but you have the same on slide 16. You have the same thing in California. You have unemployment insurance and the employer training tax. You have employees who are supposed to be contributing to disability insurance, as well as withholding on their income tax, and a similar hierarchy of penalties. So it can really add up and cost quite a bit. On the benefit side, we mentioned before, there's the qualified plan issue. Not only did you potentially fail to include someone, or conversely, you could improperly include someone. That could result in a discriminatory effect of being more inclusive than the plan actually called for. But on the welfare benefit side, you have the extension of medical coverage and health coverage, and do you have the right groups covered, and is it discriminatory, and is it fairly implemented? And it just runs through equity compensation and fringe benefits and all these other areas as well. So it can really extend. Now on slide 17, I can tell you a little bit about the IRS. This is a big problem, and if you're under audit with the IRS, the penalty, the consequences can be pretty severe. Though they do have a formal program in place where if the IRS is auditing you, they have certain flexibility as to how they can settle. But there's been a voluntary program around for the last couple of years, and it's amnesty-like, and it allows people to kind of come into the tax system. And what they're saying is that you have to have consistently, improperly misclassified your employees as independent contractors, and you have to have filed Form 1099s for them for the prior 3 years. You can't be under audit at the time of the application for this voluntary relief. And there's some other, you have to agree to extend the statute of limitations for 3 years, beginning on the date that you convert your workers to employee status, and a few other criteria. The program has not, and it's been updated also after 2011. There have been some additional updates to it, but the program is not as widely, it's been used, but people are always wary of voluntarily going into the IRS. And I think that the downside is that you get a fresh start on your federal tax liability, but the IRS can't waive state taxing authorities' ability to collect taxes or impose interest or penalties. So there's a little bit of the unknown there. But a lot of states have put in a voluntary program as well. And on slide 18, David will talk about some of the other implications of misclassification.
Thank you. The first issue I wanted to discuss with you was wage and hour. Employers have a responsibility to track the hours that the employees work. Typically, when they believe a person to be an independent contractor, they don't track those hours. However, if it's found that the person was an employee and not an independent contractor, you can't go backwards and recreate their hourly rates, the time they worked, whether they worked overtime, perhaps an hourly rate of pay. It's very, very hard to go backwards. So one of the risks that employers have is they're not able to demonstrate the hours that the person worked, and they may be responsible for minimum wage. They might be responsible for overtime. They also may have other benefits under an employee manual, for example, sick pay, holiday pay, vacation pay, that have not been provided to the employees. And this can result in exposure to an audit by a governmental agency on the state or federal level. It can also result in a potential class litigation or individual litigation brought by an attorney on behalf of employees. That's a risk that exists for the employers when you misclassify. On slide 19, we're going to talk about some of the anti-discrimination laws. For example, the Family Medical Leave Act, which provides that a person is able to go out on leave for an extended period of time. If the worker is being classified as a worker, a independent contractor, as opposed to an employee, and the worker is sick or a family member is sick and they have time away from their job as an independent contractor, they likely are not getting compensated. And someone else will come in and do the job. Under the Family Medical Leave Act, there will be a responsibility to hold the position open for that person for up to 3 months. We're not going to be honoring that responsibility that we have. Under the ADA, there might be a responsibility to enter into an interactive process and see whether or not a reasonable accommodation can be provided to that worker. We're missing that opportunity. Under Title VII, we might be looking at a situation where a person may make a claim that there is, for example, unequal pay. It's a female working as an independent contractor, and they're arguing that the person should have been paid at a higher rate similar to male employees. We run into all of these different issues. And we also have exposure, for example, on workers' compensation. If a person is working as an independent contractor and they get hurt, maybe they should have been on our workers' comp policy. That becomes a very real and significant risk, that we face in these situations, which goes back to the importance of being aware of these laws and then thinking about what we're going to do to avoid any potential pitfalls down the road. So on slide 20, Steve and I are going to address some things that can be done by you to prevent these kinds of misclassifications. And the first one that comes to mind is to have a process in place in each and every company that will ensure us that we are taking the best possible steps to protect against a misclassification. And one of the recurring themes that I experience in my practice, and Steve, I'd be interested to hear from you in a moment on this, is that oftentimes the relationship is entered into without involving human resources or without involving some of the senior officials in an organization. And they don't know that we've got a relationship with Bob as an independent contractor or Jane as an independent contractor. And what winds up happening is we don't know how the company is communicating with the people. Are we controlling who is brought in to do work? Are we controlling how the work's being done, when it's being done, how we're paying the person, how we're supervising that person's work? And because we don't know about it, we're not in a position to address it. So the first thing would be basically to have a company-wide edict that no one is able to enter into an independent contractor relationship with an individual without going through a process. Steve, have you experienced that at all with some of your clients?
Yeah, we've seen that where, past is prologue. Some situation develops where there's a legitimate bona fide independent contractor onboarding, and then as you mentioned earlier, just through the simple lapse of time, that independent contractor has been there so long, they sort of really have become an employee without you really being aware of it. Though in the early days, there might have been a legitimate independent contractor relationship, and people just aren't kind of monitoring and kind of reviewing the status. So I've seen that. I've seen that in variations of it before.
Yeah, now, in that situation, imagine all those health insurance payments that have not been made, by the company on behalf of that individual. Maybe there's a retirement plan. None of that money has been paid to the individual. Maybe the individual would not be exempt from overtime, and we've got overtime at time and a half, with double or triple damages depending upon what state we're in. The consequences can be huge. One of the things we also urge you to do is review the agreements with the independent contractors, so that before you enter into the agreement, let's make sure we're doing a due diligence and that we're satisfied that this person is, in fact, an independent contractor. And, in fact, if you're close, if you're not 100% sure that you meet this threshold for independent contractor, err on the side of caution and call the person an employee. It's not worth it. And Steve, could you talk about, reviewing the work and direction to the contractor?
Yeah, well, I think just generally, that gets down to a control issue. At the end of the day, it's subjective. We know that management control over the employee or the alleged employee is one of the key criteria. These tests are all nuanced a little bit depending on the facts and circumstances. So it's really hard to come up with a particular edict here, other than to say, to go back to what you said before in terms of process. I think that if your company has independent contractors, and I would also add a third category that we didn't mention earlier, or you think you're leasing employees, and that you have in effect leased employees, I think that there's a couple of things you can do. You can really take a big step back at this point, understand the potential consequences, and just take a real look at a bona fide restructuring and potential redocumentation of who are your employees, who are your independent contractors, who are leased to the appropriate parties, have the right levels of control or lack thereof, and just give yourself a little mini audit, and we can help you with checklists or contract language and what have you to kind of take a self-assessment. Absent specific facts, it becomes a little bit it's a little bit hard to put out black letter rules of law in this webinar. So I think that's one thing you can do, is just take a step back in that way. The other thing to do, if you are under audit or you feel one is imminent, or you feel as though you might have been lucky so far, but your instincts and judgment are telling you that you may have crossed the line, take advantage of a voluntary reclassification program, either by voluntarily going forward or by calling on the more lenient provisions under audit, whereby at least on the IRS side, they're allowed to provide some leeway on these issues, because they realize that a lot of times they occur inadvertently. And then the third thing I would say is, if you feel as though independent contractors are an important part of your business, or just makes sense in your business model or the growth of your company at the moment, and you just really can't quite manage internally where you stand with the employee independent contractor distinction, don't have the resources for it, then that might be a good time to call on one of the licensed professional employer organizations or leasing companies and have them provide some support. But in any of those scenarios, there are a lot of legal issues and some unknowns that need some clarification and guidance. So that's what I would say in terms of kind of managing the process and training your people internally. I know we're just over the 30-minute mark, so I would ask at this point that David, if you have a final comment, please speak up. Otherwise, I will ask that we move to slide 21. And I will note for you that my next webinar, I practice in the ERISA investment management space most of the time and deal with the tax issues of the independent contractor issues here. I'll be having another webinar on March 26th, and you'll receive information about that. David's next monthly webinar, which many of you follow, will be in April. I know he'll look forward to having you join him on that. And if you have any questions on slide 22, our contact information, just give us a call or shoot us an email, and we would be glad to respond and be helpful in any way that you can. So on behalf of the Wagner Law Group, David and I thank you very much for joining us today, and we hope that you have a pleasant afternoon. Thank you.